Lords, lady, before the short adjournment, I addressed you on Jay's Supermarket, and you will recall that I took you in the course of my submissions to 3 witness statements in the supplementary bundle, and I made a submission that the witness statements were not considered. Lords, I do maintain the submission that the witness statements made by the workers were not considered, but I accept that the witness statement made by Mr. Ramachandran, the director, was considered. I also respectfully maintain the submission that there is no reasoned engagement with all 3 witness statements. And I'll leave it to the court then decide whether to accept or reject that submission. So I'll address you now on Prestige. If you have the supplementary bundle, sorry, my apologies. If you have the core bundle in Prestige, may I ask you to go to page 278 of that bundle.
Yes.
Page 278 is the Secretary of State's letter of 26th of March 2024. By this letter, the license was suspended.
So are we, if we're being strictly accurate, are we dealing with the earlier iteration of the guidance in Prestige and the later iteration in Jay's Supermarket?
Yes, but it makes the
It makes no difference, I know, but just so that
yes,
these things have to be written down.
yes.
So we're here in an earlier stage of 2024.
Yes. Paragraph 3, the Secretary of State relied on paragraph C 7.26 of the guidance. You'll see the text appearing in bold that you pose a serious threat to immigration control. On the next page, paragraph 2, the Secretary of State says that we have concerns that, and then subparagraph 2, your sponsored workers are not occupying genuine vacancies. So this business has issued 111 certificates of sponsorship. So it's a massive, big business. The Secretary of State does not identify any particular worker, does not say that Mr. X or Ms. Y is occupying a vacancy that is not genuine. Simply says your workers are not occupying genuine vacancies. Nothing more than that. So the person who is said to be occupying the non-genuine vacancy is not identified. There is obviously no allegation of dishonesty or deliberate wrongdoing. The claimant.
Do you want to deal with the other 2 concerns?
The other 2?
In that paragraph 4.
No, they're
the
not.
disproportionate volume of certificates.
Yes. So that's
acting as a supplier to others.
No, So the point about 4.1 is uncontroversial. It matters not. 4.3 was ultimately dropped, so it's not an issue. The issue here is really the genuine vacancy point, and the relevant employee is not identified. There is no further details, and of course, in due course, you will consider whether this was a clear indication of the allegation. The claimant sends Prestige sends correspondences. Etc. And there is a further supplementary letter. There is a further suspension letter. That is at page 272. So the Secretary of State now says that I have received your representations, but I'm not sort of revoking your license now. I'm suspending it. And this letter now sets out my concerns. The Secretary of State relies again on C 2.76, as was the case previously. Paragraph 4 is uncontroversial, that a number of sponsored workers are no longer sponsored, so no issue with that. Then if you go to paragraph 9, there is a reference to a person named Kaur Rajbi. She's referred as Miss K in the judge's judgment. You stopped sponsoring Kaur Rajbi because they were unable to drive. For any role critical requirement, it is your duty as a sponsor to request and assess the evidence from the candidate that they are suitable for the role. Failure to do so constitutes a failure to comply with your sponsor duties. So no allegation of dishonesty, deliberate wrongdoing, and no allegation even that this isn't a genuine vacancy. The allegation is that there is a failure to comply with sponsor duties. So unlike the other case, there's not even a reference to genuine vacancy in this letter. There isn't even a person identified who is said to be occupying non-genuine vacancy, and it is certainly not alleged that Kaur Rajbi is occupying a non-genuine vacancy. The next document is the revocation decision, page 266. Despite the fact that sort of revised suspension decision made no reference to genuine vacancies, you'll see that that is now the primary reason for revocation of the license. Page 266, we revoke your license. You'll then see a heading non-genuine vacancies. And if you go to page 268, you'll see that for the first time, the Secretary of State says at paragraphs 11 and 12 that the role of Rajbir Kaur was not a genuine vacancy, or at least suggests that that is the case.
So which paragraph?
So paragraphs 11 and 12.
Thank you.
That Rajbir was recruited for a role that she was unable to carry out. And then we conclude that at least some of the vacancies you have filled are not genuine. With respect, it's not clear what is meant by some of the vacancies. The only vacancy that the Secretary of State has identified that is not said to be genuine is of Ms. Kaur. But the claimant was not put on notice that the Secretary of State had that suspicion about Ms. Kaur, that the Secretary of State suspected that the claimant was dishonest, or the vacancy of Ms. Kaur was a non-genuine vacancy. The first time that appears in a decision is the revocation decision. Paragraph 16, the Secretary of State relies on NXC 1Z and 2A and B and revokes the license. In my submission, this is an unfair decision for all the reasons that I've submitted earlier. The decision is also an irrational decision. But before I explain why that is so, may I ask you to look at paragraph 20 and 21 of the decision. So NXC 1Z is the mandatory ground. The Secretary of State says that the guidance for sponsors makes it clear that downgrading is appropriate if circumstances limited to those listed in Annex C2 or C3 arise. It's plain that the Secretary of State revoked the license as opposed to downgrading it first. was because of NXC1Z conclusion. If the court concludes that that conclusion is either unfair or irrational, in my submission, the decision will not stand. So next is the judge's judgment. Page 66 of the bundle. This is quite comprehensive judgment. Over 100 paragraphs. May I just take you straight to the paragraphs that are relevant to the issue that the court is dealing with. So if you go to page 34 of, page 99 of the bundle, 99 of the court bundle, paragraph 55, you'll see a heading summary, and the judge there summarizes his conclusions on law. The first conclusion is that the meaning of NXC1Z has not previously been settled by the Court of Appeal or the High Court. That, with respect, is wrong because it was settled by Prestwick, but it matters not for the reasons that the judge gave subsequently. The reason why it matters not is because the judge accepted at Roman II that a conclusion that a conduct falls within any of the examples listed, any of the examples of non-genuine roles listed in ground Z, do entail findings of dishonesty or reprehensible conduct. And here, the Secretary of State relied on NXC1Z. So that is correct. So is the third point. So if NXC1Z applies, then that means that procedural safeguards discussed in SCL apply. That is, in my submission, correct. Fourth point is that there could be circumstances where the Secretary of State may decide that a vacancy is not genuine without finding dishonesty or reprehensible conduct. Well, that may or may not be correct, but it's not, in my submission, an issue in this case because the Secretary of State relied on NXC1Z in the decision that I've just shown you. But again, it matters not because if you look at the fifth point, you'll see that the judge says that, well, Balajigari SCL, but the strict rules do not apply, but the requirements of fairness as set out in Prestwick apply in any event. So the Secretary of State's failure to put the claimant on notice that she suspected that the role of Ms. Coe was not a genuine vacancy at any point prior to the revocation decision was, in my submission, plainly procedurally unfair. I also said that it was irrational because the judge found that it was irrational. The reasons for that conclusion are at paragraphs 70 to 73. So in due course, I ask my lords and my lady to read paragraph 70 to 73. I submit that those reasons are plainly correct. The conclusion that that role was not genuine is plainly irrational. Well, in particular, for the reasons given at the end of paragraph 72 and paragraph 73. So that means that the Secretary of State's decision revoked the license on the basis of NXC1Z is irrational and unfair. If you accept the submissions that I made this morning, in my submission, it would follow that the judge should have quashed the decision rather than upholding it by reference to Section 31(2)(a) of the Senior Courts Act 1981. That really is ground one. Ground two arises if the court rejects the first ground, and that concerns the judge's conclusion as to the serious threat to immigration control provision and Annex 2 of the guidance. The findings that are relevant in relation to those grounds are at paragraph 63 and 68. Paragraph 63 to 68. Of course, you will, of course, read these reasons in full. But may I ask you to look at the end of paragraph 66, which is at page 106, and see what the judge has found. The judge says that the defendant was entitled to find that his recruitment alone was a failure of process, especially in the context of a high staff turnover posing a threat to immigration control. A threat to immigration control. And then paragraph 68 at the end, that there was a failure of the recruitment process. But when I showed you, my lords, the relevant part of the policy, my lords will recall that it referred to a serious threat to immigration control. So these findings, in my submission, do not justify a conclusion that this business posed a serious threat to immigration control. I accept entirely that there was a failure of the process at the business in relation to the matters that the Secretary of State has identified. But Annex C2 of the guidance referred to the business not using a process or procedure necessary to fully comply with your sponsor duties. It is impossible for any process or procedure to be immune from error. So the finding by the judge is that there was a failure of the recruitment process in relation to two matters. But that does not mean that there was a systemic issue at the business. And therefore, the premise on which the judge declined to quash the decision was flawed and wrong in law.
So did the judge use the serious threat or threat to immigration control as the support for his Section 32A decision? Is that right?
No.
So why is this relevant then?
So the judge relied on Annex C2 A and B.
Yeah.
And Annex C2A refers to a breach of sponsorship duties in Section C of the guidance.
Yeah.
And the judge essentially said that, well, the fact that there's a serious threat to immigration control is effectively a breach of Annex C2A. And secondly, there's a breach of Annex C2B because there was a failure of the process in relation to two matters. I mean, that is my understanding and submission of the judge's judgment. It's quite a comprehensive judgment, and I say this with respect. It's not entirely at points it isn't entirely clear what the judge was
No,
saying.
I don't blame you for that, and it's my own failure. I can't quite follow. But this appears under issues and principles, which starts at paragraph 56. Was the defendant rationally entitled to conclude ground Z was made? And paragraph 66 and 68, as I read them, were all part of that discussion. So it all fed into ground Z, which he then sets out his conclusion and section 31(2)(a) above section 74. So what I hadn't understood was exactly why your attack on this mattered. I mean, it may do, but I hadn't quite followed it.
No, essentially for that reason, if you look at Lord, if you look at paragraph 74,
yeah,
you'll see heading ground Z, immateriality, and section 31(2)(a).
Yeah.
So the judge has already found that ground Z is vitiated by an error of law. Under that heading, the judge says that, well, I cannot decline to grant relief because there is a public law error in relation to ground Z. And the judge is correct, so there is no challenge to that. But why the judge dismissed the claim, it's paragraph 76 onwards. Was the defendant rationally entitled to find NX C2 grounds?
Onwards. Okay, thank you.
Yeah, so he then sort of links his earlier analysis under these heads.
Thank you.
And hence you have grounds 2 and 3.
Thank you.
But grounds 2 and 3 would arise if you, in my submission, if you are against me on ground 1.
Yeah.
I'm very grateful. So unless I can assist you any further, these are my submissions.
No. Mr. Malik, thank you very much. Yes, Mr. Howard.
I'm grateful, my lords, my lady. In terms of batting order, I'll seek to address you in relation to the grounds on Jay's Supermarket, which was the matter I represented the Secretary of State on before the High Court in front of Deputy High Court Judge Atkinson, King's Counsel. My learned friend, Mr. Yarrow, who sits beside me, will take the second and third grounds of prestige, and because, of course, there's an overlap in relation to ground 1 to that which is pleaded in Jay's Supermarket. In terms of how I'll seek to address the court as to the Secretary of State's case in relation to this application to appeal, I'll be led mainly by your lordships and my lady, because a number of matters which my learned friend has raised in the conduct of his submissions were not raised, at least in the pleadings explicitly, and indeed require a response. But that which was raised is set within 2 skeleton arguments, and that's where I effectively focus my submissions. You will have, and I'll begin with Jay's Supermarket. There are a number of grounds, well, 2 main grounds within Jay's Supermarket, which I will deal with. But to begin with, I want to address a number of matters which my learned friend drew the court's attention to in relation to the policy and the relevance of the policy within the context of a privilege and how that was put before their lordships in the case of Prestwick before this court.
Before we get to that, do you mind if I just ask, you did put in a respondent's notice.
Yes.
Is that being pursued?
So, the Secretary of State's position is to contend for the matters which are raised within the respondent's notice to be dealt with as per what is written. I'm simply going to address those matters which are raised by my learned friend. So, the Secretary of State maintains, obviously, the points raised within the respondent's notice, and there may be more nuance on that as to how in Jay's Supermarket Annex C2 was dealt with, because that overlaps with the findings in Prestige as to Annex C2 and how that applies in relation to Section 31(2)(a). But I'm not going to positively assert, given the conclusions reached by Deputy High Court Judge Atkinson, King's Counsel in Jay's Supermarket, or conclusions which the Secretary of State seek to uphold in this hearing. I don't seek to undermine those conclusions in relation to Annex C2, other than to say that if your lordships and my lady were going to make a finding as to how the proper application of Section 31(2)(a) applies to Annex C2, then Deputy High Court Judge or His Honour Judge Tyndall sitting in the High Court in Birmingham dealt with that properly in relation to Annex C2. And I can qualify that submission by what is in the wording of the judgment itself that appears in both decisions by the Secretary of State, which is the inclusion of the word individually in relation to revocation, as to any of these grounds individually will result in a revocation. But I can iron out that point in due course and I can take you to the relevant decisions. But that would be as far as I seek to persuade your lordships and my lady today in relation to the points raised within the respondent's notice.
Thank you.
Could I turn the court then to tab 8 within the bundle, which is the decision in Prestwick to which my learned friend drew the court's attention to.
Sorry, so we are at...
So tab 8,
Yes.
Prestwick in the Court of Appeal. And I'm beginning at page 272, paragraph 21. Sorry, paragraph 20. Now, I won't seek to read out what's within those paragraphs because I'll take it that that can be reviewed at a later junction. But these are the points which the Secretary of State has sought to rely on in both cases, and indeed are extrapolated across a number of cases that were set down by Lord Justice Haddon Cave in the case of Raj and Noel. But they effectively qualify, and the submission I'll make in due course, that this is a forward-looking exercise by the Secretary of State when applying her policies. And that's an important point to bear in mind when one comes to consider their Lordship's considerations of both appeals, or their Lordship's consideration of both applications for judicial review subject to this appeal, because paragraph 20, which is the most useful paragraph, effectively outlines that this is a voluntary scheme. And that's important because it qualifies the nature to which the Secretary of State seek to interpret her policies and how she then seeks to interpret the compliance with duties by those who benefit from a sponsorship licence. It is a privilege, and that's an important consideration. Although my learned friend addressed the court in saying that the individuals, or at least the businesses, have a right to be considered in line with policy, that is a very different consideration from the starting point that this is a commercial benefit by way of a licence, which is as part of a voluntary scheme.
Well, can the two propositions not both be true? I mean, the Secretary of State doesn't have to set it up, but having set it up and made it voluntary, then has to comply with her policies. Otherwise, there's no point in setting out policies.
Of course. But the point I'm seeking to make good is that as a result of it being a voluntary scheme, the Secretary of State is then entitled to approach compliance, an assessment of compliance with the duties in the policy as set down by Lord Justice Haddon Cave at paragraphs 21 through 22 of Prestwick. And that's important because how it is phrased within those principles is that subparagraph 1, the essence of the system is that the Secretary of State imposes a high degree of trust in sponsors granted licences in implementing and policing immigration policy in respect of migrants who it grants certificates of sponsorship. And then, of course, number 3, must maintain its own records with assiduity. And those principles are repeated again in that there's no need to wait for the Secretary of State when considering whether or not a breach has occurred or might occur. Number 7, can treat matters with a high index of suspicion and a light trigger. And that's important in the context of my learned friend's submissions as to impact or outcome of revocation, which I'll deal with in due course. The point being, and it'll feed into the submissions as to how Annex C1Z is to be interpreted, because it's very different, and I'll submit in due course, to what Balajigari was seeking to find, or what Balajigari was determining, is that it's only a reasonable belief, and that's enough when one looks at these principles that set down for the Secretary of State, or at least assess the powers of assessing compliance, are effectively preemptory and forward-looking in that assessment.
Those are all the statements from Lord Justice Helen Cave. Was there a guidance that set that out, or a policy that set that out?
Well, these are the common law principles that have been applied by the Court of Appeal when assessing the actions by the Secretary of State in seeking to revoke or suspend sponsorship licenses for breaches that occurred or might occur or suspected as having occurred. The point I'm seeking to make good is that it's a forward-looking exercise, and it's done with a light trigger because the ramifications can be serious, when the opposite is the benefit is a commercial benefit. So that's important again when one considers what was determined in the case of Gold Care, which is at page 298 of the authorities bundle, at paragraph 110 of Presswick. Where Mr. Manknell, like Queen's Counsel, cited the observation of Alison Foster, Queen's Counsel, in her judgment in Gold Care 2019 in the High Court, paragraph 36. Procedural propriety depends on the subject matter of the decisions, the executive functions of the decision maker, and the particular circumstances in which the decision is made. And also that what fairness requires depends on the character of the decision-making body and the kind of decision it has to make, and the statutory or other framework in which it operates. And then that turns us to what the policy says, at least what I would submit being the...
That was the submission that Mr. Mankwell was making. Do we know what the court said about it? Because 110 is in response to the third ground, and paragraph 111 is as to the fourth ground. Now, you may be right that the court accepted it, but I suspect we need that paragraph.
My understanding was that the court accepted it in the context to which it was being made. I'm simply relying on the principle. Yes. Sorry, my lord. It's a general principle of public law. That's the reason why I'm relying on it, because I'm turning now to the policy and how that should be applied. And that takes me then to tab 12. And it's important here because within this policy, my learned friend places much weight on C9, which is at 412 of the authorities bundle, which is in relation to suspending your licence. The submission I seek to make good is that's not relevant in the context of the decision under challenge, because it's not a challenge to the suspension decision, it's a challenge to the revocation decision, and the task of the Secretary of State is set down within C10 at 415. So the time at which C9 applies has passed. We are now looking at C10, and this is a point which was grappled by His Honour Judge Tyndall sitting in the High Court within his determination. And the key difference here is that my learned friend says the starting point is downgrading the licence, but that's in relation to suspension and not in relation to revoking your licence. And I take you to paragraphs C10.4 and C10.5. It says how we decide whether to revoke your licence. The point my learned friend is seeking to make good was on Annex C2. That's at C10.5. It says Annex C2 of this document sets out the circumstances in which we will normally revoke your licence unless there are exceptional circumstances. And that's important because that's what His Lordship, in the case of Prestige, grappled with at some length and gave 5 reasons to his conclusion as to why there were no exceptional circumstances that applied within that case. So that revocation followed on the consideration of section 31(2)(a) in the alternative, but in any event in isolation. So the next point, which is important in the court's analysis, is that my understanding from a learned friend's case wasn't that this was a challenge as to seeking the definition of what amounts to a genuine vacancy. Maybe it's my understanding of how the case has been pleaded, but even taking that as it may, turning to page 386, and this was a point that was expressly made good in the case of Prestige. We're looking at C144, which is the genuine vacancy definitions. There's no challenge within the grounds of appeal on Prestige that His Lordship was wrong to make a finding that there's a difference between C144, which I believe he coins as non-genuineness grounds, which do not allege dishonesty, as against those which are found under C146, C147, which are dishonesty grounds for the purposes of Annex C1Z. That may be a moot point and it's not subject to this appeal. And I'd simply submit it's irrelevant when one goes to consider the grounds in, or at least the determination in Prestige, and isn't relevant to the consideration in Jay's Supermarket, because His Lordship found that there was a dishonesty element to the Secretary of State's case, and I'll deal with that in due course.
Sorry, I not entirely followed your submission on C144.
So C144, a genuine vacancy is one which, and then it gives three examples. That effectively is if I could phrase it as this, as an evidential threshold as to amounting to a genuine vacancy.
Yeah.
So if I was, say, a sponsor and I was applying for a license, in order to make good the certificates of sponsorship, I would look at that and say, well, in analysing this candidate for job A, they need to meet the requirements for that job. In other words, they have to perform the specific duties and responsibilities for it, and then meet the requirements for the relevant route, etc., etc. So it effectively could be determined as a evidential threshold. I know it was coined as a non-genuineness element, which doesn't necessarily require submission as to dishonesty or reprehensible conduct. The submission being that something can amount to being there is no genuine vacancy for the purposes of C1Z without there being a dishonesty element to it, simply because the evidence has not been provided to establish that the role exists, or another element under C1Z.
Thank you.
Is it helpful, I'm just thinking out loud, to try and categorise what classes of allegation allege dishonesty and what don't? I mean, isn't the practical and proper approach for a decision maker to approach matters on the basis of the facts in the individual case. I mean,
Yes.
of course, it's going to fall within certain parts of the guidance, but it might be thought to be approaching matters from the wrong end to say, well, that part of the guidance inevitably involves an allegation of dishonesty or not an allegation of dishonesty. Isn't it simpler just to look at the facts of the individual case, see what's being said about them, and then proceed fairly in accordance with the sorts of issues that are being raised? I don't, at the moment, if an attempt is being made to say, well, that part of the guidance is a special case because any allegation of that kind will be an allegation of dishonesty. It may be possible to say, well, when one looks at a certain part of the guidance, that's true, but it's not the starting point.
No. And I would agree with my lord, because simply the reason why I'm making this submission is that there is no set definition in terms of what has to amount to dishonesty or not. I'm simply submitting that within the case of Prestige, there is a difference as to what amounts to dishonesty and what is non-genuineness. And the point being, or at least the point raised from my understanding by my learned friend, was trying to say that in every case there must be the phrase used of dishonesty when relying on Annex C1Z, which can't be right in my submission. And the difficulty which their lordships had in the case of Prestwick was that, I don't know whether it was my learned friend's submission, but what was relied on in terms of seeking to establish the procedural requirements in making an allegation on Annex C1Z was the well-rehearsed principles set down in Balajigari. Balajigari is a very different case. Balajigari was about an individual who was accused of dishonesty by way of a finding, or at least the finding wasn't made, but was required as a result of Balajigari. And that's very different here. And their lordships didn't grapple with that in the Court of Appeal, but in Prestwick. And that's very important to my submission, because my learned friend tries to make good this point by saying the outcome as a result of the draconian revocation is substantial. But that's not correct. That's not what's within the policy itself. There's no evidence of that submitted in the lower courts. And my learned friend can't point to examples in this case or across the case law where that point is made good. Unlike in Balajigari, the individual, as far as I understand it, was banned from re-entering the United Kingdom for around 10 years. Dishonesty allegations for the individual who makes an application for indefinite leave to remain are substantial. It is a finding, and rightly so. Their lordships in Balajigari set down procedural requirements in that regard. But what we have now extrapolated from Balajigari and Prestwick is a heightened standard of fairness when an Annex C1Z ground is alleged, which I submit cannot be right in the context of a sponsor license being a privilege and not a right. Because the privilege, sorry, my lord.
So you're saying we shouldn't follow Prestwick?
It's not within the grounds,
No,
but it isn't. And it's not been raised by my learned friend in the grounds. I'm simply responding to the point that was raised today in submissions, from my understanding.
I mean, Balajigari is consistent with the common law
Yes.
principles of fairness.
Yes.
And this requires fairness as well. I mean, just because they're a company, they're still entitled to have a fair chance to deal with allegations. So
Yes.
there's that. But are you submitting that any part of Prestwick we shouldn't follow?
I'm simply submitting that that point wasn't nuanced within the determination as to how Balajigari dishonesty was, the outcome applied, and indeed how the enforcement of that outcome would apply to an individual as against a company who's granted a license by way of a privilege. It's very different. And that's important because part of my learned friend's case on ground one in Prestige is in relation to the outcome, and substantial points are made in that regard. And I'll deal with those when I come to deal with Prestige. But it's very different, and your lordships will see that within the determinations themselves, and it's the concluding remarks in Prestige, that Annex C 1016 simply says there's a cooling off period, and that if you've had your licence revoked for any breaches previously, that you have to make good those breaches, but that an application will be considered the same as any other application. My learned friend's submission differs from that in simply saying that it has draconian effect because you have an allegation of dishonesty against you. But there's no evidence to suggest that that therefore means the Secretary of State will consider your case on a new application differently to any other application, because that's not what was within the policy itself. It's not what the policy says. So the outcome element to my learned friend's submissions is wrong, in my respectful submission. The outcome is the same whether it's revoked under Annex C1Z, Annex C2AB, or in the possible event that it's revoked under Annex C3. Revocation and outcome are the same in terms of the consequences. There's a cool-off period, and you have to make good the breach. And it coincides with what my learned friend was. If your licence is downgraded to grade B, and you don't meet those requirements set in the action plan, and it's revoked, you're in the exact same position as someone who's been accused of, in my learned friend's words, dishonesty under Annex C1Z when you come to make good a brand new application once the cooling off period has expired. So it's not the same as the individual in Ballyjagary. And as such, their lordships did not grapple with that point in Prestwick, which is a very important consideration when one comes to consider the gravity of an allegation under Annex C1Z as against the outcome in terms of enforcement. Now, that point was raised, respectfully to my learned friend, for the first time in oral submissions before Deputy High Court Judge Atkinson, Keen's counsel. I don't take issue with that because it is in the pleaded grounds, but it simply doesn't go as far as my learned friend would like it to and flies in the face of what's within Annex C 1016. The next point in terms of the policy itself, which I'll seek to make good when we consider the decisions in the respective cases, is that my learned friend, with respect, initially accepted that stating within a decision that a role is not genuine for whatever purpose under Annex C1Z is enough, and that it means dishonesty. My learned friend then took the course in submitting that you have to say dishonest in order to make good the requirements in Prestwick. That's not correct in my respectful submission for three reasons. The first is it's not in coinciding with the principle and goal care referred to by Mr. Magnall, Keen's counsel, in the case of Prestwick, to which I drew your lordships and my lady's attention to a moment ago. The second is that what Prestwick was actually concerned with in terms of procedural fairness on the consideration of the complaint in SCL was the inclusion, if I could just take you to that determination, at page 304, was that there is a failure to set out with clarity that the Secretary of State for the Home Department suspected that SCL had deliberately exaggerated the role in order to facilitate her stay in the country. Now, that's the factual analysis at page 304, paragraph 1 through 7, to which you were drawn your attention to earlier. Because that wasn't done in SCL. That's very different from saying that there's a requirement to say dishonest. I take that point from the principle set down in paragraphs 133 to 136. Because what my learned friend's submission amounts to, if it's made good, at least in the case of Jay's Supermarket, is that the Secretary of State should have put in place, which is not in policy, when one considers the requirements of considering procedural fairness within the context of statute and policy, before the decision maker, is a successive stage that simply says, okay, you're dishonest, what's your answer? for the exact same reasons which were set down in suspension decision, the initial revocation decision, and thereafter within the reconsideration decision. What my learned friend's submission, if it was made good, would require the Secretary of State in those circumstances to have another layer. And that flies in the face of the common law principles of fairness. All the Secretary of State must do is set out her concerns clearly and indicate on notice to the individual, or at least in these circumstances within the policy, to the sponsor licence holder, the concerns as to breach or suspected breach that might or may have or even may occur.
But it also seems, speaking of myself, to be a somewhat theoretical debate, this, because in the present cases, it's not as if either of the appellants is saying, I had no idea you were suggesting that I had been naughty in some way. It's not a case in which the argument below was on the basis, but of course I didn't put in the evidence that I could have put in because I didn't realise that they were concerned about this. I mean, it appears to me at some stages, with all respect, as if this argument is untethered from the facts of the actual cases with which we're concerned.
Your Lordship has cut to the chase of
And,
where I'm
and,
going.
and if it was a problem of that kind, then no doubt those instructing you could quite easily put in a boilerplate paragraph in every single letter that goes out,
Yes.
which includes the word dishonest, for example. But there we are.
Well, there's 3 points on that. The first is the complaint is immaterial in the context. The second is my learned friend, at least in Prestige, says Ms. K, the complaint or the concern is Ms. K was not put forward within the suspension notice. I'll deal with this in due course. It was done. And then the third point is effectively, well, the third point brings me back to what I'm seeking to argue in relation to what the policy actually says about, within the context of procedure fairness, what the Secretary of State ought to do. And that's what's being done in this case, and that is a suspension stage. Albeit, Secretary in relation to Annex C1 doesn't have to go straight to a suspension, it can revoke immediately. But we know the general principles of procedural fairness would be to give an indication as to that. And one could suggest, Senior President, Lord, you made reference earlier about attending at the scene effectively and asking questions. One could suggest that that is enough in the context of giving notice, but then of course there's no criticism being raised by my learned friend in the grounds of that as to what was said within interviews or otherwise, so that's a subsidiary point. But within the context of the policy itself, what does the policy require within the context of gold care? And if we actually just go back and look at C144, I'm sorry to jump around, I know there's a lot of documents. This flies in the face of, first and foremost, my learned friend's analysis of Prestwick in saying that there has to be the phrase used of dishonesty. But it also can't be right because dishonesty is not used within the policy. Those words are not used. So my learned friend's submission in saying that this is unlawful by virtue of what is said in SCL isn't right, because it's not what their lordship said in Prestwick, but equally, my learned friend's whole case hinges on the fact that if you say something's not a genuine vacancy, that's dishonest. You're alleging dishonesty. So dealing with basic principles, then you will be well aware if you're being accused of dishonesty if there's the words genuine vacancy on the page. And if we look at Annex C1Z, it's clear what
What
the...
page?
Sorry, my lord. 423.
Thank you.
point C1Z saying is we have reasonable grounds to believe the role for which you have assigned as a certificate of sponsorship is not genuine. And then it goes on to say, for example, because it, and then gives a number of examples. But they feed back to what's within C144 to C146.
Yes, but if you are putting in a decision letter for the first time that the job is a sham and you've not given someone an opportunity to deal with it, then that's grossly unfair.
Yes.
Yeah.
But that wasn't done in this case. And
Yeah,
of course.
Principles
Of course. But even looking at this, and going back to what I was making a submission or seeking to make good in relation to Balajigari earlier, was that Balajigari was about before making a finding of dishonesty, that must be put to the individual. Well, as I've said, within the regime of sponsorship, it's a privilege, it's a license. The Secretary of State can operate a light trigger approach, and all that's required in terms of the policy is that there's a reasonable grounds to believe. It's not asking for a finding from the Secretary of State before C1Z is invoked. That is, in my respectful submission, a lower threshold than what was required in Balajigari. I'm not saying that the Secretary of State shouldn't have put the individual, or at least the business in this case, in either case, on notice. But, my lady, my lords, that was done. So any submission which is being raised by my learned friend that both appeals should succeed on the basis of Annex C1Z requiring a direct finding or allegation of dishonesty is not made out both in the law and in the policy within the context of the task before the decision maker. This is a forward-looking assessment, and if the Secretary of State has any concern as to a breach that has occurred or may occur, she can suspend and then revoke. But we're at the revocation stage. And as such, she does not have to stipulate an exact allegation of dishonesty, because that is not what the policy says. And sponsors sign up to this policy must be aware of its contents. So one could submit that when they see an Annex C1Z reference to the role is not genuine, the duty is on them to be aware of their own requirements for compliance. And that is why it's seen throughout the case law, there's no duty on the Secretary of State to spell out exactly what documents or indeed what response should be made by the applicants for judicial review in those cases, or the sponsors as a whole. Because it is a system of trust, it is implied that the trustee of the licence has a requisite level of understanding with their duties under this guidance. And that is very important in the context of the letters to which I'll take you to now in J, Supermarket and Prestige. So, my lords, just taking you to the core bundle within the case of J Supermarket, and I qualify my submissions by my earlier points on principle. There are three key decisions in this case. There is the initial suspension decision. I'll just give you the dates. That was on the 22nd of August 2024, to which there was no response. There was then the initial revocation decision on the 10th of October 2024, to which the claimant's instructed solicitors advanced a very detailed pre-action protocol letter along with a number of associated documents, such as witness statements. Now that you can see the list, my lords, my lady, at page 271 of Jay's Supermarket Bundle. There's 12 items referred to there as list of documents in support of reconsideration. So there's the PAP letter. Now, the Secretary of State, whether it could have been challenged or not at that point, that's a moot issue. The Secretary of State could have maintained their decision to revoke at that point. But what's really important in this case, I submit, as I did in the lower court, was that there is a successive step that makes good any argument that there's been a procedural unfairness. That's subsidiary to the main point that, in line with policy, the procedural fairness requirements in common law have already been complied with by the initial suspension letter. The Secretary of State gave a successive step by way of the reconsideration letter of the 12th of November 2024. Now, there's nuance within those submissions because, of course, my learned friend says that when we consider the 12th of November 2024 reconsideration, it did not consider the witness statements. My Lords, a number of points are raised by my learned friend and my lady, apologies. There are a number of points raised by my learned friend in relation to this element of ground one as to witness statements, but that was not within the statement of facts and grounds, and it was not pleaded within the skeleton argument before the lower court. That rose by way of oral submissions. So my learned friend in his skeleton argument accompanying the grounds seeks to make good the point that the Secretary of State's case has never been that the decision maker considered the witness statements. And my lady, my lords, it isn't put and was not put in the lower court, at least it's not within the grounds, that the Secretary of State failed to consider the statements of both workers. The argument is put that the Secretary of State failed to consider the witness statements collectively that were filed with the pre-action protocol letter. Now, why is that relevant? Because my learned friend is seeking to argue that his lordship in Jay's Supermarket entered into an error of law. And that cannot be right in the context of a matter that was not pleaded. And we know the requirements under Tapalda, which I won't...
So can you, if you're going to make this submission, can you just take us to the pleading so we can see
Yes.
them?
Unless my little friend corrects me, I'm wrong on that, but my rereading of the statement of facts and grounds is that this wasn't directly pleaded, and I'm beginning at page 216.
Of the core bundle?
Yes. So, my lady, my lords, you'll be aware there is a number of grounds advanced in this case, some of which permission was refused, and then there was a renewal application made, and as such the Secretary of State dealt with within her detailed grounds 8 grounds of review. The first being at page 228, irrational conclusion that NC's role is not a genuine vacancy, general sponsor duties, and so on. I'm sure my lady, my lords will read that in due course. But besides that point, it is raised in these grounds, and I will address it, if I may. For completion, or to completely make good my point, the skeleton arguments for the claimant in the lower court begin at page 132 to page 143. Now that's very different, I submit, from my learned friend saying that the point as the Annex C1S was not raised. It was raised within the Secretary of State's skeleton argument, but I'll deal with that in due course in relation to ground 2. But just looking then, if we may, it was my lady's point earlier to my learned friend Mr. Malik King's counsel that the reconsideration decision that we have at page 237 introduces for the first time, and rightly so, a number of entries as to reconsideration. This was a point I was going to raise in oral submissions today because my lady has made good the point. Those are direct quotations from the witness statements. Now, my learned friend has not sought to go behind the opening remark of this reconsideration, which is that the Secretary of State considered the representations. 2 points flow from that. One is a point in law, and another is a point in fact. Taking the factual point, if we go to page 253, we will see in page 253 submissions made by the claimant's instructed solicitors. These are detailed, lengthy, and consider a number of matters which were, in some regard, not all, considered before the High Court. But what is striking about this pre-action protocol letter is that it directly quotes from the statements. Not just the director's statement, but both workers. It has never been my learned friend's case that the Secretary of State failed to consider the representations. His case now, is put after the luncheon adjournment, was that there was a failure to consider the workers' statements. The point I make factually is that flies in the face of an acceptance that the representations were considered. It flies in the face of the fact that those statements are quoted verbatim within the representations considered. And it flies in the face of the fact that within the reconsideration, that letter is quoted verbatim from the statements. Which concludes my submission. It is an immaterial point because the statements are quoted and they're referred to, and what you have then is a reconsideration as a result of the pre-action protocol representations. So the two hangers to which my learned friend places his coat as to procedural unfairness is that the Secretary of State did not allege dishonesty verbatim within the letters. That's not correct. I haven't taken you directly to the wording, but I will very shortly and briefly. And the second point is that there's a failure to consider the representations by way of statements. I've dealt with the latter point. The Secretary of State clearly did. And indeed, Deputy High Court Judge Atkinson, King's Counsel, reached those conclusions himself, correctly and rationally, in my view, based on the evidence. My learned friend has failed to make good that point. In terms of the decision letters themselves, it has always been the Secretary of State's case that Prestwick was complied with within the ambit of my submissions as to Ballyjagary, qualified by the fact this is a privilege, within the initial suspension letter. There may be now at this point a crossover between bundles. I beg your pardon for the lifting of these hurdles. But if we just go back to the authorities bundle within tab 8. To Prestwick, yes, my lord. If we could just go to page 303 and 304. My lady, my lord, will have my point on this, that the Secretary of State does not have to make reference to dishonesty or go as far as their lordships did in Prestwick, because the test is the Secretary of State sets out her concerns and puts the sponsor licence holder on notice of her concerns and gives a fair opportunity to respond. That's the common law principle. But even if we were to apply how my learned friend seeks to navigate this case, the factual analysis, what was complained of in SCL was, if we go back to the Jay's Supermarket decision, and we look at paragraph 8 and paragraph 18, the conduct complained of
what? The judgment.
of the decision. Sorry, so I'm
So what were we looking at?
so we were
precedents for?
apologies, my lord. In SCL,
Yeah.
paragraph 137.
Yeah.
So paragraph 137, where the C is,
Yeah.
it says, in relation to SCL, the Secretary of State entered into an error in that it failed to set out with any clarity that the Secretary of State for Home Department suspected that SCL had deliberately exaggerated Ms. Rima's role in order to facilitate her stay in this country. The first time the Secretary of Home Department expressly told SCL that she believed the company had exaggerated the role to facilitate her stay here was in paragraph 21 of the revocation letter. And taking my lords and my lady back to the suspension decision in Jay's Supermarket at page 284.
284.
284 of Jay's core bundle, paragraph 8. This is taking my learned friend's case at its highest, of course. You have my primary submission on this point. Paragraph 8 says, at page 284 of the core bundle of Jay's Supermarket, we therefore believe that the role of retail manager does not constitute a genuine vacancy within your business, and that the role has been created in order to facilitate Mr. Chandra S. Karan's leave to remain in the United Kingdom. So even if we look at the factual analysis in SCL, that is met in the suspension letter in Jay's Supermarket. But then what you have after that is a decision on revocation. So if my learned friend was correct in saying, well, Prestwick wasn't complied with, I disagree with that, but Prestwick wasn't complied with because there wasn't a fair notice. Well,
I'm having a little trouble with this. It's my understanding that the sort of notice that was given in SCL was very similar to the sort of notice that was given in the present case of Jay's Supermarket. We look at paragraph 65 of Prestwick, which is at page 286. That's the paragraph 21, which is really the equivalent of paragraphs 8 and 18 in the present case. And therefore, it seems to me that we may have to grapple with the fact that, that this court considered that that wasn't good enough in this case. But you may wish to distinguish it. But I appreciate you're going to go on to say it doesn't matter.
yes.
But I think we can't simply go around the back of Prestwick,
Of course.
if the facts are exactly
Yes.
the same.
May I turn my back just one moment, my lord?
Is that is the revocation letter, isn't it?
Yes, so that-
65. And the paragraph 21, the first time it came up, was
Yes.
in the revocation.
Correct.
The point is, it hadn't been set in the earlier correspondence.
Yes.
That's the point. It's the sequencing.
Exactly.
It's not
Yes.
that there's some difference in the level of explicitness. about
Yes.
what it is. All right. Well,
So I must say, my point is, as you know, explicitness is irrelevant in the context of what is done in this case in Jay's, because what happened at the revocation stage in SCL happened at the suspension stage in Jay's Supermarket.
And that's what you're taking us to, for example, at page 284, paragraph 8. You're
Yes.
saying that is in the suspension letter,
Yes.
which is earlier in the chronology.
Exactly. And that's where SCL determined that there was unlawfulness procedurally in SCL because it only appeared in the revocation letter.
First time that
First time it appeared.
arises is later down the line.
Yes. And even if my learned friend was correct on SCL, they had...
Different here, you say.
It's very different, yes. That's my starting point. But nuancing my learned friend's submissions in the skeleton, even if my learned friend succeeded in saying the suspension letter was wrong, it didn't give fair notice, I make good the successive step point, which is you have a revocation decision that explicitly said Annex C1Z and the other annex grounds, which then resulted in a PAP letter that dealt with explicitly the concerns raised within both the suspension and the revocation decisions. Then you have the successive step of fairness, going on my primary submission almost too far, but out of fairness it was done. A reconsideration decision. So the materiality of my learned friend's submissions on ground 1 are not made out. And that's ultimately the Secretary of State's point on ground 1. And because of those submissions, ground 2 effectively falls away. But
Ground 2, just remind me, is the section 31.
Yes, ground 2 is the section 31A, section 31.2a point as to effectively the Secretary, His Lordship correcting an error, which was the use of Annex C1Z or the failure to include the word dishonesty and give a successive step. Because I submit that the decision as to Annex C1S being used by way of Section 31.2a should be upheld because the underlying facts of this case have not been challenged. And if we look at what Singaram says in the Court of Appeal, where is the prejudice? And I can take your lordships and my lady there, if I may, very briefly. It's at tab 9. And I'll not go through it in much detail, but it's tab 9, page 318. It's a really, it's really useful entry in this decision. I believe it was Lord Justice Phillips, paragraph 49. I'm halfway through that paragraph. It begins by way of example. So extrapolating that principle to this case, it says, it is long said that there is no such thing as a technical breach of natural justice, and a court should not find a breach of natural justice, now more commonly called procedural fairness, in the absence of substantial prejudice to the individual as a result of the procedural failing.
Sorry, where are you now?
I'm at page 318 of the authorities bundle, paragraph 49.
And what authority is this?
This is the case of Singaram. In this court, on the 30th of October 2025. So 2025 EWCA Civ 1375 behind tab 9.
And that's not in the law reports anywhere?
Sorry, my lord.
It's not been reported, this judgment?
I'm not sure I take your lordship's meaning.
Has this been reported?
Oh, no, sorry. Not that I'm aware of, no. So there's 2 points that can be made as to paragraph 49. The first is what their lordships are considering in Singaram was the application in relation to an individual in similar circumstances, it could be said as Balajagari, where rights are in play. But even taking that principle at its highest, my second submission, and applying it to the context of a sponsor holding a license under the regime, if we looked at where is the substantial prejudice to the sponsor, which I submit could be determined as could be considered is a different test because it's not against an individual with rights, but against a sponsor. But even be that as it may, the appellant at no stage within Jay's supermarket, by way of evidence, submissions, or any other documentation, has set out any substantial prejudice in the context of any procedural unfairness alleged, or as a result of the revocation, which isn't disapplied by way of any global assessment. So again, I hit home, I hope, on the second ground of Jay's supermarket, in that there's no error identified in Deputy High Court Judge Atkinson Keen's Counsel's decision, because Singaran says there has to be substantial prejudice, taking the appellant's case at its highest. There isn't any, I submit. There was comprehensive submissions made within the PAP response. Those were considered in the reconsideration. And the underlying facts that go to Annex C1Z are directly applicable to Annex C1S. And the only difference between the two, taking my learned friend's case at its highest, is that there was a failure to say dishonesty on Annex C1Z, as per the appellant's interpretation of SCL and Presswick. But I'm simply submitting, well, if that's the case, then Section 31(2)A could apply, because the outcome's exactly the same on revocation, and the underlying facts have not been changed, because the task of the court is one of review, and the facts have not been held to be irrational on the conclusions reached, and there's no evidence which the appellant has submitted to undermine the factual conclusions I would submit. So the point being is, Annex C1S can apply directly to the facts of this appeal in relation to this appellant, both under Annex C1S as it could under Annex C1Z for the reasons I've submitted. My lady, my lords, with your leave, I then turn to Prestige. So my learned friend has set out within the skeleton argument on the case of Prestige 5 points on ground 1 that I interpret need to be addressed. And there's been some overlap, albeit more detail, in relation to Jay's supermarket. But the 5 points are effectively that His Honour Judge Tyndall, sitting in the High Court, was wrong to make a finding under Section 31(2)A for 5 reasons. First being that there was an error as to outcome. The second was that there was an error as to process, therefore Section 31(2)A cannot apply, albeit my learned friend in the course of his submission resiled from that point. The third point is that there's an error because the starting point is downgrading and reliance is placed on Annex C9, which, as I've already outlined, relates to suspension, not revocation. The fourth point is that it is alleged, by way of error, that the judge sought to make prediction. And the fifth point is that the appellant was unable to make representations, and that's submitted to make good the procedural unfairness as to exceptional circumstances. Taking each point in turn, for the reasons I've already outlined, that is wrong. I say with the greatest respect, because my learned friend's grounds, despite what's in, I would submit a clear judgment when one reads it in detail, that Annex C1Z was found to be an irrational conclusion by the Secretary of State. But my learned friend's submissions are on the basis that Annex C1Z and any conclusion reached meant that the decision was unlawful. But that isn't right, because His Lordship in Prestige differentiates the two because, and very aptly put, I may say, by my learned friend, Mr. Yarrow, who sits beside me, there's 2 bites of the cherry on the section 31.2a point. There was the Annex C1Z point, and then there's the alternative, the Annex C2 point. Now, my learned friend hasn't sought to go behind, at least it wouldn't make sense for my learned friend to make the submission that the conclusions in Annex C1Z were wrong, because that supports his case. But what my learned friend seems to be doing is, by way of the fact that there was an Annex C1Z error, that means any finding on Annex C2 cannot be made out. That seems to be resolved from today. But in any event, that cannot be right. And his lordship in Prestige deals with that very clearly in my submission, based on what's within the revocation, or the revocation decision. And this is the point, Senior President, my Lord, made earlier, is the Secretary of State still standing by the respondent's notice, because this is relevant to the consideration as to how Annex C2 should be considered.
Well, that's, I asked you, in fact, about the respondent's notice in Jay's Supermarket, but there's a separate one in Prestige.
It's an overlapping point. I suspect my learned friend would say, well, if the case is correct in Prestige, that the alternative, or well, if the case is correct on Jay's Supermarket, that Annex C2 cannot be relied on for the purposes of Section 31.2a, although it's not directly pleaded, then Prestige must fail also, because the finding in Prestige was that Section 31.2a applies by virtue of the findings in Annex C2. Now, I've sought to make good the point, I hope, in the policy, that when considering revocation, the starting point is not, as my learned friend says, under suspension under C9, but under C10, it's we will revoke your license, normally revoke your license, sorry, unless there's exceptional circumstances. And that's my learned friend's 5th point, which is failure to be given an opportunity to make representations, but I'll deal with that in a moment. I would submit, of course, that the correct course was taken in Prestige as to the analysis of Annex C2 in the question of Section 31.2a, and with the greatest respect, Jay's Supermarket should have made the same analysis. And I will differentiate the two fairly, I trust, for this entry within the decision itself in Prestige. And if I can just take you there now, it's at page 265 of the Prestige bundle.
Core bundle.
Sorry, my lord.
Core bundle.
Core bundle, Prestige. And it is at page 270.
And this is the decision letter, 15th October.
Yes, my lady. Now, at page 270, His Honour Judge Tyndall, sitting in the High Court, came to the conclusion that at 270, paragraph 21 said, "You have acted in contravention of a number of issues contained in the Workers and Temporary Workers Guidance Responses. We are satisfied that each of the following individually is a necessary basis for revocation." And it goes on to say non-genuine vacancies, Annex C1Z, as well as the other issues noted within this letter, Annex C2A, Annex C2B. That was enough in Prestige to make a finding, or refuse relief, under Section 31.2a. That's important in my submission in relation to the respondent's notice on Jay's Supermarket, at least, because if we look at the determination in Jay's Supermarket, it doesn't consider the phrase individually. But that phrase is included within the decision letters in Jay's Supermarket.
In Prestige.
As well as in Prestige. Both decisions in Prestige and Jay's Supermarket say, we are satisfied that each of the following individually is a necessary basis for revocation. His Lordship in Jay's Supermarket did not deal with that point in detail. What his lordship did was break down what Annex C2 said as to normally, and simply said, I can't, well, effectively couldn't predict what the Secretary of State could do, but within that decision does not make the same reference to what is made within Prestige, that is, we are satisfied that each of the following individually is a necessary basis. Sorry, excuse me. Yes, of course. My learned friend is indicating to me that the conclusions on Annex C1Z in relation to the application of Section 31(2)A, the conclusions reached in Prestige, I understand, were incorrect because what his lordship could have done is look at paragraph 12.
What was incorrect?
Sorry, I may have mistaken my learned friend's point. Sorry, I'll leave it to my learned friend to address in his submissions. I think it'd be put more clearly and misunderstood.
So where are we on this point you're trying to...
Sorry, yes, so the point I'm grateful, my lord, and the point I am making was at paragraph 21 of the decision at 270, is that entry at paragraph 21, at least up until it says, is a necessary basis of revocation, applies in both cases. But in Jay's supermarket, the paragraph isn't dealt with within his lordship's determination. It's irrelevant in the context of the refusal for judicial review, but relevant in the context of how Section 31(2)A should apply in my submission, because that point is made good by my learned friend in Prestige.
And that's your respondent's notice?
That's the respondent's notice on that point.
And in Prestige, it's paragraph 86, the judge deals with paragraph 21 of the letter anyway.
Yes, I think that's where it begins with prediction. Yes, it simply says that the grounds on A and B and Annex 2 are untainted by the conclusions reached by the judge on ground C1Z. The judge concludes 86, I could therefore be satisfied that it is highly likely that without ground Z, the actual decision would still have been revoked. The actual decision would still have revoked the licence, sorry. My lady, my lords, I've dealt with, as I said at the beginning, my submissions in Prestige, there was 5 points in Prestige. Previously dealt with the point as to outcome. Simply want to make good that submission by reference to the policy itself. This is the first limb of my learned friend's submission on ground 1 as to Section 31(2)A in Prestige. But if we go to the authorities bundle at page 488, you'll see here at 488 of the policy, the section titled Reapplying for your licence after it has been revoked. You have my learned friend's submissions on outcome. I made reference to the Secretary of State's case a moment ago, but ultimately it's not in keeping with what's within this policy. And you can see that at C1016, it says once your licence has been revoked, you cannot make a further application for a sponsor licence until at least 12 months have passed since the date we notified you of the revocation. It goes on to say this is known as the cooling off period and may be longer than 12 months in some circumstances. For example, if there is revocation due to civil penalties or criminal conviction, but that is not this case.
And then you draw attention to C10.18.
Yes, my lady.
If you apply again after the cooling off period, we will treat it the same as any other application.
Yes, my lady, exactly. And that's where I submit a revocation for the purposes of Annex C1, C2 or C3 are exactly the same.
Well, doesn't the last sentence of sub-paragraph 18 come into play then, so that if you've been refused, revoked for a more serious reason, you'll have to show better reasons for getting back on the list.
And ultimately,
I mean, it strikes me,
yes,
without regard to the policy, that it's not likely to be exactly the same. No doubt you have to get a fair consideration when you apply
yes,
after the cooling off period, but you'll have more to show if you've been refused for a more serious.
I would submit
Fault.
yes, in the extent that the Secretary of State, you're known to the Secretary of State, you've previously breached,
Yeah.
and the Secretary of State will be drawn to immediately that, well, you breached previously for recruitment processes, say, we will look at those in detail and see if you've overcome that
Yes, but
failure.
it's one thing that if you didn't keep your records very well because you hadn't hired a bookkeeper and now you have, or whatever it is. It's another thing if you're just an untrustworthy person who's importing people and for non-genuine purposes.
Yes.
Stands to reason.
Yes. But in terms of applying the facts to this case and my submissions in Annex C1Z, it's only a reasonable belief that's required for Annex C1Z. And as your Lordship correctly identified earlier, effectively putting colours on the mast as exactly what amounts to an allegation of dishonesty or not meeting the evidential standard on the Annex C1Z would possibly be too restrictive going off what's in the policy itself. It will have to be fact or case specific as to how C1018, C1018 applies.
But in this case, it was common ground that it was effectively dishonesty, wasn't it? Or that was the allegation.
That was the allegation for Jay's Supermarket, not for
Jay's
Prestige.
Supermarket, yeah.
In Prestige, that point would be made good, I suspect. I'm not I would be speculating, say, if they remedied the recruitment processes. But ultimately, as it's treated as any other applicant, someone who applies for a licence, as I submitted when I opened the Secretary of State's case, it is a high threshold in any event. Someone who seeks to obtain a sponsorship licence has to comply with the duties and the compliance guidance in any event. So whether or not there's been a previous breach will have to be remedied, yes, but doesn't go as far as saying the outcome is different for the purposes of Section 31(2)A as per my learned friend's submissions. And the point I was making good, I sought to make good in the lower court, was that the difference, at least in Jay's Supermarket, the difference between a revocation on C2 and C1 for the purposes of Jay's Supermarket was no difference was no different, because they would have to make good the errors on C2 and would have to make good the errors in C1 in any event by virtue of C1018. But ultimately, the outcome is revocation, and there'd be a 12-month cooling off period. So that's where I lend support, or at least seek support from His Lordship's consideration and Prestige, as ought to have applied in Jay's Supermarket on Annex C2. And I would invite your Lordships to make a finding in that regard for the reasons I've submitted. Second point in relation to this ground one on Prestige, conscious of the time. Because my other friend, I have to address the court on grounds 2 and 3. But the second limb to Prestige, ground 1, is the error of process But for the reasons I've already identified, and as within the judgment itself, I would submit my learned friend puts his case incorrectly here because there is no error of process. The judge did not say Annex C1Z is irrational because you weren't given notice of it properly in relation to say Ms. K, but I'm going to make that finding in any event. That's not a finding which was made in the lower court. So I would submit, as to how section 31.2a was used for Annex C2, it's an irrelevant submission. I've addressed you as to point 3, which is the starting point. It's not C9, it's C10, which I've taken you to previously. The fourth limb is important, and I know I've already drawn your attention to it in some detail, is the element of prediction. His Lordship didn't seek to make a prediction because the determination was already made within the decision itself for the reasons I've already outlined. The inclusion of paragraph 21 within the decision in Prestige clearly sets out, or paragraph 21, sorry, individually, Annex C2.1 or Annex C2A and Annex C2B separately are enough to refuse relief and to accede to the conclusion of revocation. And my learned friend seeks to conclude his submissions on ground 1 of Prestige, saying that he was, or apologies, that the claimant was, or the appellant was, unable to make representations. In other words, the common law principle of given fair notice of concerns and a fair opportunity to make representations in response. His Lordship dealt with in detail within Prestige, and a number of conclusions were reached. And I can take you to those, if I may, within the core bundle in Prestige at page 121. Now, starting point is, my learned friend's submission is that C9 applies, and that the beginning starting point is that it should be downgraded. I've already identified that that's wrong by virtue of C10. But even considering what was before the judge and before the decision maker, similar to Jay's supermarket, his Lordship here considered exceptional circumstances. And we know that's relevant from the entry in C10 when considering an Annex 2 case, because Annex 2, C2, will normally result in a revocation unless exceptional circumstances are found. That's exactly what his Lordship analysed in Prestige and made 5 concluding remarks. And most telling of those coincide with my submissions from the case of Singaram. There is no prejudice identified. It cannot be said in either case that the appellant did not know the case to meet, that they were not on fair notice of concerns, and that they did not have a fair chance to make representations. And for those reasons, I would submit my learned friend's arguments in ground 1 in relation to Prestige and the 2 grounds in Jay's supermarket are not made out. Unless I can assist my lordships any further.
Can I just ask, what are you doing about page 41 of the core bundle and your respondent's notice attacking paragraph 73 of the judge's judgment? We to ignore that?
Yes, my learned friend's going to address that.
Right, so we're not to ignore it, but you'll be doing. I thought you were just doing the grounds 2 and 3 rather than the respondent's notice.
Apologies, my lord. Grounds 2 and 3, and then probably 30 seconds on the respondent's notice.
Thank you.
Can I have just for my lady?
No, thank you very much indeed. Yes, Mr. Yarrow.
I'm grateful, my lords, my lady. Could I begin just before I leap into ground two, just very quickly, to clarify, if I can, a small element of ground one of the prestige appeal. And the court might be assisted in this because, as has already been indicated today, the judgment of His Honour Judge Tyndall is long and winding, and I don't mean that in a pejorative sense, but it explores many different avenues. And I had the privilege of arguing it before him at the time, and so it might just assist in helping the court determine what he found. My learned friend, Mr. Malik, King's Counsel, was looking at paragraph 55 of His Honour's judgment in Prestige, which one can find at paragraph 99 of the core bundle in Prestige. And looking at the summary of the conclusions that His Honour Judge Tyndall set out in paragraph 55. And I was just slightly concerned about the characterisation of Roman numeral 2 in the context of what he decided. Because as I understood it from Mr. Malik KC, my learned friend, the suggestion was that His Honour Judge Tyndall had found that if one revokes under Annex C1Z, then that necessarily entails an allegation of dishonesty. Actually, what His Honour was saying was where one revokes by reliance on any of the examples under Annex C1Z, then those are implicatory of dishonesty. So the examples in C1Z are where the role doesn't exist, where the role contains an exaggerated or incorrect job description, where the job was created in order to enable someone to come. And as I understand it from Jay's Supermarkets, it's the created that is being relied on, C1Z, one of the examples, so that does carry an implication of dishonesty. In Prestige, however, the license was not revoked under any of the examples under C1Z. It was revoked under C1Z, but not by reference to one of the examples. Instead, it was revoked under C1Z by reference to not meeting the definition of genuine set out in C144 of the guidance. So, my lords, my lady, very, very briefly, if we can turn to page 454 of the authorities bundle. And I know we've traversed this already, so I won't trouble the court with this for very long.
454.
454.
Yep.
One can see at paragraph C144 what's referred to by His Honour Judge Tyndall as a closed set definition of a genuine vacancy. C144 tells us what genuine vacancy means. It A, requires the job holder to perform, etc. I won't read. It B, does not include dissimilar. I won't read. And C, is appropriate to the business in light of its business model. That's the positive definition of genuine vacancy. The negative definition, the examples of a non-genuine vacancy are set out in a non-exhaustive examples list, and they are under C146. And they are role doesn't exist, exaggeration, creation, etc. And so what His Honour Judge Tyndall decided, which I say is the correct decision, is that one can use the words non-genuine and revoke under Annex C1Z without any allegation of any of the reprehensible conduct that's implied by C146, but simply because the role does not meet the definition of C144. And that's in fact what he did. If one goes through the judgment, rather than just looking at that summary page, which is slightly unclear, and looks at how he reached that conclusion, one can see very clearly that that is what he has decided. And in the case of Ms. Kaur, that is what happened in Prestige. There was no allegation that the role doesn't exist. There was no allegation that it had been exaggerated. There was no allegation that it had been created to enable her to come to the United Kingdom. There was merely an allegation that the role did not require her to perform the specific duties and responsibilities for the job because she couldn't drive and the job required her to be able to drive. So it has to be a starting point for this appeal that there is no allegation of dishonesty in the case of Prestige. And that puts the premise of at least two strands of the argument by Mr. Malik KC under ground one of Prestige. It takes away the premise for those arguments because one doesn't need to follow Balajagari where there's not been an allegation of dishonesty. One falls back on the Bank Mellat principles, which are not as enhanced as Balajagari. And also, it affects the outcome argument being put forward by Mr. Malik KC because the outcome is exactly the same. There's no finding of dishonesty under C1Z, there's no finding of dishonesty under C2. So even if he were right that the Secretary of State would view those applications differently at some point in the future, that eventuality doesn't arise here because there has been no suggestion of dishonesty on the part of the claimant in Prestige. And I made that clear below. I made it clear that no allegation was being relied upon below before His Honour Judge Tyndall, and he didn't find it, and I maintain it today. So that was just very briefly, just to ensure that ground one was not being argued on a mistaken footing. If I can then deal with, because I am conscious of the time, grounds 2 and 3 very quickly and indeed together. My learned friend makes the proposition in his skeleton that the words threat to immigration control have to be read sensibly and in context. And I wholeheartedly agree with that proposition. Of course, they need to be read sensibly. And of course, it's true that in any recruitment exercise where one is sponsoring a migrant worker, there is always the potential for some risk. But we are a long way on the factual findings in Prestige. We are a long way away from the levels of inherent risk that exist just generally in a migrant worker sponsorship context. On the facts of this case, we have strong established facts here of poor recruitment practices on the part of the claimant, which have led, in the case of Mr. F, as he's referred to the granting of a certificate of sponsorship to someone who could not pass the English language test, and in Ms. K's case, to the allocation of a role which required driving to someone not only who couldn't drive, but who had positively told the claimant in her application form that she could not drive. So had already given them the necessary information before her recruitment that she could not satisfy the requirements for the role. That is clearly more than just the small amounts of inherent risk that exist in any recruitment exercise. If I could go, my lords, my lady, to the guidance or the policy, as it's been referred to in these proceedings, and canter through it. My page numbers are references to the later policy, the one that's being used in the J Supermarket case. My Lord Justice Peter Jackson has indicated we want to make it clear what's being referred to. Because there's no distinction, when I give page numbers, I'll be looking at the J Supermarket case, even though the policy was actually slightly different in this case. So to start with, on page 377, guiding principle, sponsorship is a privilege, not a right. It's already been referred to both by the appellants and on our side already, so I won't dwell on it, but C1(3), significant trust is to be placed on sponsors, and they must ensure they comply with immigration law. That's the key passage from that. The most important paragraph, which was referred to below on this issue, is found on page 384, and that's paragraph C138. And that sets out the obligations for compliance with immigration laws. There's a number of bullet points. The first bullet point is potentially of relevance in Ms. Kay's case, because the first example is only employ workers who are appropriately qualified, registered or experienced to do the job. Well, in her case, the job required driving and she could not drive, so she was not appropriately qualified, if one calls a driver's license some kind of qualification, but certainly experience to do the job in respect of driving. And then if we turn over the page onto 385, the penultimate bullet point, similarly, only assign a certificate of sponsorship to a worker if you are satisfied they intend to and are able to fill the role. And of course, in Ms. Kay's case, she couldn't. She was unable to fulfill the role. So that's an example of where there is non-compliance with reference to C138. Jumping forward then through the guidance to some of the sections that have been relied on the other side. If we look at page 402, and look at paragraph C7.3, the guidance says there, we will continually monitor sponsors' compliance and take action against those who, first bullet, pose or may pose a threat to immigration control. And that may pose there is reflective of some of the case law on the light trigger and the forward look, as my friend Mr. Howth put it, that the Secretary of State has to take when making evaluative decisions about compliance. Not just pose a threat, but may pose a threat to immigration control. If we go on to some of the sections that Mr. Malik Casey relied on in his submissions, we go to page 405 and the section headed Outcome of Compliance Checks. We've already had the discussion that C725 and C726 go, as my Lord Justice Peter Jackson put it, go cheek by jowl in determining minor issue versus more serious breach. We also have C24, which talks about breaches or posing a threat to immigration or not conducive to the public good as an alternative to a threat to immigration control rather than being something included within it. And then in C726, we see the initial phrase, where there is a more serious breach indicating. So we start with the breach, and then it's what the breach indicates. That's the correct analysis of what we're looking at in C726. Has there been a breach of one of those requirements under section C1 that we looked at just now, C138? Is the person able to fulfill their role, etc.? Where there is a more serious breach indicating either A, a significant or systematic failing, and in this court there's been some discussion, I know from a different case, about the difference between systematic and systemic, but effectively really that should be a systemic failing.
I put that behind me.
Pardon me? Yes, my lord will remember it well, the discussions of systematic versus systemic. But what it means in this context is a failure of...
It caused exasperation at about the same time as the day.
Yes, my lord.
Last time as it does today.
Yes, my lord. Well, here, I submit the meaning is plain. It means a failure of the system. It doesn't mean a concerted approach or whatever it was that systematic might mean when it means something different to systemic. It's a failure of the system, and it's one of the examples under C726. And the third bullet point is you pose a serious threat to immigration control. I should say that this is the only place where the word serious, which my learned friend Mr. Malek KC relied on significantly, this is the only place where serious is coupled with threat. Elsewhere, in C10, for instance, where I'm about to go, it's just threat to immigration control. And what I would say in this case is we clearly have that. We have a systemic failing because we have the failures in recruitment practices that have led to the recruitment of Mr. F and Ms. K. And we have also the evidence of the high turnover of staff, which is significantly in excess of the industry standard, which indicates difficulties in recruitment or failures in processes in the claimant's recruitment practices. So we have that systemic or systematic failing, and we've been talking about the serious threat to immigration control. Just to make good the point, I obliquely referred to a moment ago, on page 415, which is section C10, which is the section that we are most interested in for the purposes of these proceedings, on revocation. C10.1, circumstances can lead to your sponsor license being revoked. These include, but are not limited to, and then where. Again, third bullet point, serious or systematic breach of sponsor duties. And fourth bullet point, you pose a threat to immigration control. No use of the word serious in that context, in the context that we are interested in. In any event, even if this were, if the word serious had import, it would be met easily on the facts of this case. My lords, rather than turn to it, and my learned friend Mr. Howarth has already referred to it, when perhaps thinking about ground 2, if I could pray on your indulgence to reread the summary of the propositions of common law from these cases that are set out in paragraphs 21 and 22 of the Prestwick judgment. It will be Authorities Bundle, page 272. But in essence, it's Lord Justice Haddon Cave, when he was merely a Justice of the High Court, in Raj and Knoll, which he then added 4 more propositions when he was later a Lord Justice in the case of St Andrew's College. So there are, I think, 8 propositions in paragraph 21, and then there are further 4 additional propositions in paragraph 22. But all of these propositions, the general tenor of them is all, as my learned friend Mr. Howarth has already said, emphasises the light trigger, the high degree of suspicion, the forward look of the Secretary of State, the level of the quickness at which she's expected or can be allowed to act in circumstances where there's not just something which is seriously threatening to immigration control right here, right now, but which might be, and the word might is used in in the case law which might pose a threat to immigration law. So I rely heavily on all of those propositions, which demonstrate quite how serious the Secretary of State is entitled, and the court's leeway that they give her in determining that there are problems with a sponsor, which enables her to take enforcement action against by way of suspension, revocation of a license. And words like vitally important are used. In my submission, if one looks at the findings of His Honour Judge Tyndall about the factual findings about high turnover of staff, about the recruitment of Mr. F, about the recruitment of Ms. K, in my submission, it was plainly open to the Secretary of State and entirely rational of the Secretary of State to have found that there was a threat to immigration control being posed by the claimant's poor recruitment practices, and she was entitled, therefore, to revoke the licence under Annex C2A and B as an alternative, and expressly in the alternative, to revocation under C1Z, the non-genuine roles revocation. For the same reason, ground 2 and 3 really go together. It was quite clearly a failure. These were not two isolated incidents, but were, as His Honour Judge Tyndall put them in paragraph 94, I think, of his judgment. These were manifestations of the failures of process. It was a manifestation of the failures in the recruitment practices that enabled Mr. F to be granted a certificate of sponsorship when he could not pass the English language test, and it was an error of process and procedure which enabled a certificate of sponsorship to be granted to Miss K, who was recruited into a job which required driving when she'd expressly represented in her application form that she could not drive. These, on the background of the high turnover of staff, are demonstrative of failures in processes in procedures. My Lord, my Lords, my Lady, I said I'd very briefly refer to the additional argument in the Respondent's notice. The additional argument in the Respondent's notice is, in effect, that having done all of the right exercise about C1Z in determining that it was not always implicatory of dishonesty and could just be a failure to meet the requirements of C144, the judge was thereafter wrong to conclude that it was irrational for the Secretary of State to have found that Ms. K's role was non-genuine on that basis. In essence, the facts are that Ms. K was recruited. She was issued with a certificate of sponsorship on the 13th of August. And it was not until the end of October, we don't have an exact date in the papers, but the end of October, when her certificate was withdrawn. So that was a period of 2.5 months. It's referred to in the judgment as within 2 months, but I think it must be 2.5 months. In circumstances where her start date had been backdated to June, so she had a backdated start date of June 2023, had the certificate of sponsorship issued on the 13th of August 2023, which was not revoked until the end of October 2023. In those circumstances, while the judge might have said he would have come to a different view on whether or not the role genuinely required her to drive, it was rational for the Secretary of State, within public law rationality jurisprudence, within the realms of reasonable decision-making, for the Secretary of State to say 2.5 months is long enough a time for an error such as this to have been rectified if this job was in fact genuine. But it wasn't withdrawn for 2.5 months, and therefore the inference must be that this was a role which, not dishonestly, for whatever reason, did not require the role holder to meet the requirements of the job.
I just ask for your submissions on this question of the significance or otherwise of whether a concern or issue that's raised by the Secretary of State does or does not involve dishonesty. What is the purpose of having to identify that as a preliminary matter at all? What does it add to the common law duty to give a fair opportunity to make representations about matters that bear upon a public law decision?
It's a good question, my lord. It's really the jurisprudence since Balajagari has created this almost this enhanced public law obligation on the Secretary of State in cases where dishonesty is being alleged.
What's the obligation? To spell it. The obligation
being to put the allegation fairly and squarely.
The obligation being to spell it out.
Yes, is put it fairly and squarely, spell it out.
But what does that? What's that add? One would expect that in giving people a fair opportunity to comment on matters that were likely to bear upon a decision, they should be told what the matters are in a sufficient degree of, with a sufficient degree of clarity, that they can actually respond. Of course, if the allegation is of a more serious kind, then you're going to be clear that it's of a more serious kind. But at the moment, I appreciate that this may be covered by authority or some principle, but at the moment, operating without those in mind, I'm not sure how it's helping decision makers to have a separate category of case.
No, indeed, my lord. What you've just said is
in Balajagari seems to me simply to say that if your real concern is that somebody is being dishonest, then you can't knock them out without making that clear to them.
Yes, man. That's right.
Which is highly unsurprising.
And then you have a new industry of people trying to say, well, this means that it's dishonest, therefore you've got to frame it as dishonest. It may be, it may not be.
Exactly so, my lord. This is the problem with this type of case, is that what you're having in, and I'm not instructing the J Supermarket case, but I've listened with interest to what's in the papers in that case, is where you have an allegation being put very fairly and squarely. We believe this has been created to enable someone to come to the United Kingdom, and then it being put that because it doesn't use the word dishonesty, then it doesn't fulfill the Balajagari requirements. And that can't be right. It must be, as my Lord Peter Jackson says, it must be a case-by-case question of, is the allegation on which you are relying being put fairly and squarely to the applicant? I think part of the problem is the detriment problem, because a lot of the Balajagari case law arises in that case it was a 3225 case about declarations to HMRC, etc. But in a lot of the cases, it arises in contexts where if you've had an application previously refused on the grounds of dishonesty, it carries serious consequences for you, such that you might not be able to apply for entry clearance again or apply for this type of leave to remain again.
And that's why all the common law has required people to be particular about pleading dishonesty. It's exactly the same point.
It's precisely the same.
But that doesn't help us with paragraph 73, and you were going to tell us why the judge was wrong to find that this was non-genuine.
So what I thought my Lord already covered that, which is essentially that he was saying it might be possible to form an inference that her role didn't require, the role itself didn't require her to drive, and the role was non-genuine. But he said on the facts, because it was all dealt with within 2 months, the Secretary of State couldn't rationally reach that conclusion. I'm saying it was actually 2.5 months, and because it's a rationality challenge, one only needs to be satisfied that it was within the reasonable realms of decision-making available to the Secretary of State. In my submission, it's within those bounds to say that where somebody is issued with a certificate of sponsorship that requires driving, cannot drive, and then doesn't have that certificate withdrawn for 2.5 months, that is suggestive, and therefore an inference can be drawn, that vacancy did not exist in the first place, whether innocently or otherwise. It's a very
Thank you.
I can put it that succinct. I hope that's succinct, but that briefly. My lords, my lady, unless I can assist further.
No, thank you very much, Mr. Yarrow. Mr. Malik.
My lords, my lady, five very short points. The first point concerns what Miller and Friend said about pleadings. You'll recall that Miller and Friend made a submission that my point about the witness statements not taking into account was not pleaded in the grounds of judicial review. That, with respect, is simply wrong. Miller and Friend, I'm sure inadvertently missed the paragraphs where the point is pleaded. So may I quickly just show you where the point was pleaded? So if you go to page 216 of the core bundle.
Yes.
So these are the grounds of judicial review drafted by Mr. Gaja, who sits behind me. And may I take you to page 230?
$230.
230, yes.
Thank you.
So if you look at paragraph 24.6, you'll see that Mr. Gaja referred to the witness statement of NC, quoted paragraphs 9 and 10. I took you to those paragraphs. And then 25 pleaded that the decision was perverse and infected by a failure to have regard to material evidence.
Sorry, well, 24.6.
So 24.
Where those paragraphs are highlighted. Yes?
No, the paragraph 24.6 at page 230, my lord.
Yes.
So the paragraphs that are quoted are quotations from the witness statement of Naveen, one of the workers. And then the submission is that, well, this evidence wasn't taken into account.
Well, we may be splitting hairs here, but I'd understood that the nature of the complaint was that the Secretary of State had simply ignored
Well, yes.
the witness
yes, so
statements.
yes, paragraph 25, there's failure to have regard to material evidence.
All right.
So this is Naveen's witness statement. If you look at paragraph 28.4, this concerns Manoj's witness statement. The defendant has again failed to have regard to MC's statement, which detailed his job role in more detail. And then Manoj's witness statement is pleaded. There's no doubt that this was a ground that was pleaded. The judge dealt with the ground, resolved it against J Supermarket. And ground one is and the ground revealed to this court is that the judge was wrong to do so. So there's nothing in my submission in the pleadings point.
Thank you.
The second point concerns what Miller and Friend said about Prestwick. Now, in my submission, Miller and Friend, in effect, invites you to depart from Prestwick. You have taken a note of the submissions that Miller and Friend has made. When you will reread Prestwick, you will see that those were the submissions that the Secretary of State made before the court in Prestwick. and those submissions were rejected. Now, my learned friend says that it's a forward-looking exercise. He used that phrase a few times, forward-looking exercise. Light trigger. It's not necessary to put the allegation of dishonesty. No finding of dishonesty is needed. But this is irreconcilable with Prestwick. It's not a forward-looking exercise. You're looking backwards. You're deciding whether the Secretary of State has established that there isn't a genuine vacancy, not that there would not be a genuine vacancy in future. The Secretary of State must make a finding that there is no genuine vacancy. The standard of proof is balance of probabilities, paragraph 133, 134, 136, and 137 of Prestwick says so. It is absolutely essential. Paragraphs 133.
Yeah, 133 to 136. Yeah.
To 136.
Yeah, okay.
There is a need to, in my submission, expressly allege dishonesty. See paragraph 137 of Prestwick. A finding of dishonesty is needed to revoke the license on the ground that there is no genuine vacancy. See paragraph 133 of Prestwick. Prestwick, with respect, is binding. There is no basis from the learned friend to tacitly invite the court to depart from it. You'll recall that at one point, my learned friend made a submission that Balaji Gari was a different case, and the court in Prestwick did not grapple with it properly. Well, this is essentially inviting you to proceed as a Supreme Court to make a decision that Prestwick was wrongly decided. Prestwick has decided that Balaji Gari applies in this context. My third point concerns what my learned friend said about Singaram. This is the judgment of Lord Justice Lewis that my learned friend took you to. My learned friend showed you one paragraph in that judgment. I do need to take you to that judgment to demonstrate that reliance on that paragraph is with respect, simply misplaced. So tab 9 of the authorities bundle. Now, if you look at paragraph 14 of the judgment, page 309.
Thank you very much.
So paragraph 14 of the judgment, you'll see that the applicant in that case was encountered working at a shop. He was interviewed, he was detained and interviewed. And the immigration officer made a witness statement. And if you look at paragraph 16, the immigration officer said categorically to the applicant that he was arresting him on suspicion that he is liable to immigration detention. This is because I suspect that you have breached conditions of your leave. So the suspicion that there was a breach of immigration conditions was expressly put to the applicant before the applicant was interviewed. The applicant is then interviewed, and the relevant questions are put to him. And for that reason, the court concluded at paragraph 40 that the claimant was told, and he knew the issue, whether he failed to comply with the conditions of his leave, and he had every opportunity to deal with it. There was no procedural unfairness, see paragraph 43, because paragraph 43, the questions asked gave the claimant every opportunity to explain what he was doing at the shop. When is it that he started working?
Is this a case in which this court was sitting as a divisional court?
No, this is a judgment of this court.
This is on appeal?
Yes, this is this court.
I understand that, but you will know.
No, it was an appeal from the High Court, the judgment of the decision of Mr. Justice Diaz. So this is where the High Court refused permission to apply for judicial review.
Lord Justice Lewis is giving the main judgment.
Yes.
in a claim for judicial review.
That's right. So permission to apply for judicial review was refused by the High Court. Permission to appeal was granted, and the court retained the underlying judicial review claim.
Yes, that was all I was asking. It's
Yes,
because,
yes,
original assessments are being made
Original
by this
assessments.
court
yes,
rather than reviews of another judge's
that's right.
assessments.
That's right. Yes.
Yes. Anyhow, probably doesn't.
So no procedural unfairness. And then if you look at page 317, paragraph 45, you will see that Lord Justice Lewis asked me as to what else the claimant would have said. I provided a list of what the claimant could have said in the interview, and Lord Justice Lewis said at paragraph 46 that, well, the claimant was asked these questions. And there was no, therefore, unfairness. But this case is sort of completely different for all the reasons that I've given. There isn't a compliant interview, and when you read this in this context, this provides no assistance whatsoever in my submission to Miller and Friend. The fourth point concerns what Miller and Friend said about NXC2 matters. In Jay's supermarket case, the judge dealt with the point, in my respectful submission, correctly against the Secretary of State at paragraph 114 of the judgment. And that paragraph is at page 108 of the bundle, the core bundle. May I just show you that paragraph? Page 108. So essentially, the judge is saying that, well, NXC2 matters alone are not enough to withhold relief. It is NXC1 that led to the decision to dismiss the judicial review claim. The finding of the circumstances falling within NXC2 would not necessarily have led to the decision to revoke, and might have might lead to a downgrading of license instead. This is acknowledged by the Secretary of State. Now, this is correct. If I'm right about NXC1, in my submission, the appeals succeed. If I'm wrong about NXC1, the appeal fails. Now, Miller and Friend, my Lord, the Senior President would recall that at one point said that, well, this was wrong because of the respondent's notice point. But this isn't a point that is subject to respondent's notice. This wasn't challenged by the respondent's notice. So if you look at the respondent notice, you'll see that this isn't a point that is made. There is no relevant respondent's notice point. So the respondent's notice is core bundle, page 20. And you'll see heading which says additional grounds for upholding the order, just middle of that paragraph. The first paragraph concerns fairness. The second paragraph concerns duties that Manoj and Naveen were undertaking. The third paragraph concerns a fairly high index of suspicion. The fourth paragraph concerns witness statements. And the fifth, final paragraph concerns trust. It isn't suggested by the Secretary of State in the respondent's notice that NX2 matters alone would have been sufficient for the judge to dismiss the appeal. So there is no respondent's notice point. What this judge said is correct, and this is the basis on which the court should decide this appeal, and in my submission, the other appeal too.
Was there not a material distinction in the wording of the letters between Prestige and Jay's Supermarket, in the sense that in Prestige, the letter actually said individually by reference to grounds? Do you want to address that? Paragraph 21 of the letter, I think.
Yes. May I just, I think there is no, Apologies.
Paragraph 94 of the judgment, if that helps.
Yes. No, there is no difference. If you look at page 282 of the core bundle in J Supermarket,
Yeah.
so this is the revocation decision. And if you look at paragraph 60 of that decision, you'll see that the same language is used. We are satisfied that each of the following individually.
Paragraph 60.
Paragraph 60, at page 282.
Thank you. Sorry, second sentence, yeah.
Yes. So the short point, of course, conscious at the time, is that if it's NX2 alone,
Yeah.
then there has to be a consideration of whether there are exceptional circumstances, which the Secretary of State hasn't really considered. And the court, therefore, cannot be satisfied that it's highly likely that the outcome would not be substantially different. The fifth and final point concerns the emphasis that Miller and Friends place on the word outcome in section 32, section 31(2)(a). You have heard submissions on the word outcome, but in my submission, what is also relevant is the phrase substantially different. Whether the outcome for the applicant would not have been substantially different. A finding a revocation of license on the grounds of dishonesty or deliberate wrongdoing is substantially different from revocation of license on another basis. I'm very grateful. So these were my 5 points in reply.
Well, thank you, Mr. Malik, and thank you all for your helpful submissions. We'll take time to consider our decision and let you have our judgments in due course. On the usual terms, that there should be strict compliance with the rubric at the top, that you shall kindly help us with any typing errors or obvious mistakes of fact, and that you should please submit separate draft orders reflecting our decisions in each of the two cases, and we'll then hand down the judgments electronically, not needing to trouble you to return. Thank you all very much indeed.
Court arrived April